Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. It is Saturday, January 13th, 2024. This is our 80th broadcast here on the many broadcast stations of Civic Media throughout our wonderful state of Wisconsin and beyond. My name is Jim Santelle, and yes, I'm going to be your host for the next 2 hours on this Saturday morning. This is our weekly review, our analysis, our discussion of some of the most significant, impactful news events and developments in the areas of law and government, and indeed the aspiration for justice in America. As always, I am supported and assisted so expertly this morning, as always, by my wonderful producer, Anya. She is assisted and supported this morning by our co-producer, Johnny, and together we're in the studios of WAUK Radio, but broadcasting through to you throughout regions of our great state. We have, as always, an ambitious but achievable agenda, a wonderful academic and civics-related syllabus for you this morning. I'd like to believe it's also going to be informative and maybe even inspiring to you in terms of what you can and should do in response to our discussion this morning about law and government and justice in these United States of America. As always this morning on our broadcast, the 80th broadcast of our Saturday morning show, we ask three principal questions, and we try to answer them as well. The first question, what happened? What do we know about the world in which we live, the country in which we live, the state in which we live? What are the facts that are knowable and discernible as we think about answers to the questions that come after? What happened? The first of those questions. The next question, why are those things important? Why are they relevant? Why are they material? What is significant about them? Why are we talking about them at all? And third, what do we do about those things? In many cases, there's little we can do, but in most cases, there are things that we should do in response, in reaction, in answer to those things that are populating our lives and our livelihoods here in the state of Wisconsin, throughout the United States of America, and across the globe. Those three questions, what happened? Why are those things important? And what should we do about them? All a part of our Saturday morning syllabus. Happy to have you join me for our ambitious but achievable, informative, hopefully inspiring discussion, as always here on the broadcast station, your broadcast station of Civic Media. This morning, our syllabus, again, diverse and important to understanding our world. We're going to be talking initially about some international cases. We began at the last segment of our last show last week by talking about things happening in Israel and also in Chile. I'm going to go back to those and give you more definition for them, some more understanding about why those particular stories are important and the lessons that they may share for us here in the United States of America as we begin this all-important year 2024 in the government of our country, in the politics of our nation, in campaigns for the highest offices, middle offices, all important offices of public service in our state and in our nation. We're also going to go to the nation of Suriname and talk about a significant event happening there. And then we're going to go overseas once again to The Hague in the Netherlands and talk about a major case that was prosecuted and defended just this past week. All of those things in Israel, in Chile, in Suriname, and in the Netherlands at The Hague, all of them with lessons about the rule of law and the understanding of justice in our nation as well, taken from the international world, some pieces of undiscovered justice, not much covered this past week by our national and even our local media, but important to understanding our own world right here in our own localities, our counties, our state, and our nation. Then, the second portion of our syllabus this morning, we're going to come back to the United States of America, having gone overseas for much of our first hour, and we're going to talk about some major trials that, yes, have indeed animated a lot of the media coverage just this past week. We'll talk about that civil fraud trial in the state of New York that just wrapped up yesterday, Friday, with some closing arguments by the state of New York and also by lawyers for Donald Trump. the past president, being sued in that case by the Attorney General alleging violations, state violations in a civil proceeding by Donald Trump and his sons and his company for valuations of property there in the state of New York in violation of the rules and regulations about how corporations are supposed to work in New York. Closing arguments just this past week, just these past days. We're going to talk about those as well. Then we're going to talk about another case also going ahead in New York. That one begins this coming week. It's another case in the civil arena involving E Jean Carroll. Yes, indeed, another defamation case against the former president underway in federal court beginning this coming week. Then we're going to go to Washington, D.C. and talk about what is perhaps the single most significant judicial proceeding of the week, because it may indeed affect the future of these several prosecutions against the former president. Has to do with whether or not the concept of presidential or executive immunity actually exists in America under our Constitution and under our laws. The D.C. Court of Appeals entertaining oral argument this past week in its courtroom, determining and sending us some very clear messages about whether or not this concept exists under the rule of law, under our system of justice in our nation. Both of those cases that we've talked about, the case in New York involving civil fraud, and also the Court of Appeals case in Washington, D.C., both of those attended by Donald Trump, both of them proceeding in his presence. We'll talk about that as well. And then the fourth case we're going to talk about in our second hour is one of the many cases now joining approximately 1,200 prosecutions going ahead in the wake of the assault on our democracy, on the attack on our Capitol on January 6th, this involving the prosecution of a Montana fire chief, now brought into our federal criminal justice system for his involvement in the riot on January 6th. We're going to talk about that and make sense of it in context of these other cases also involving Donald Trump. Finally, as always, we're going to chat a bit about the Supreme Court, active a lot this past week when it comes to deciding a number of different cases, hearing oral arguments on Monday and Tuesday and Wednesday. We're going to chat with you very briefly about the content of those. And then we're also going to talk more about what's coming up next week. And to tantalize you in anticipation of that discussion, I'm going to tell you more about a case coming up next Wednesday, the 17th, which I believe, even in the midst of these important cases involving the Supreme Court's attention, having to do with guns and social media and the future of our agencies and the Trump cases, this single most significant case involving something called the Chevron doctrine, and inside that agency determination, the future of our federal agencies, how they operate, and the connection between them and federal district court and appellate court judges around the country. I believe one of the most significant cases of this term, and arguably in recent terms, having to do with the way in which federal courts interact with agencies, and most importantly, the ways in which federal agencies behave and conduct themselves in connection with supporting you and providing service to you, and the kinds of things that you should indeed anticipate and expect from a government that truly is responsive to you. The United States Supreme Court is going to comment on that probably in June. We're going to talk about that case that's coming up for oral argument next Wednesday, and certainly next week in our broadcast following those oral arguments of this coming Wednesday. We'll try to read the tea leaves from the Supreme Court argument of this coming Wednesday. An awful lot on our plate today, a lot on our syllabus, but once again, ambitious and achievable, hopefully inspiring and informative along the way as well. So let us begin. Let us begin with our academic movement through some pieces of largely undiscovered justice having to do with things in our world of just these past several weeks. Again, the first of these, certainly the subject of a lot of attention overseas, and yes, indeed, in our nation as well, because as we have talked at great length on this broadcast and others of Civic Media, the interchange between the executive branch and the judicial branch, indeed the legislative branch as well, is critical to an understanding of how government works. Every single republic, every single true democracy out there has at least some vestiges in some ways of three branches of government, as we well know. That is the courts, that's a legislative branch or body that makes the laws, and then there's a branch that executes the laws, that puts those laws into operation. As you know well from our previous discussions of this particular case, in recent months, frankly, recent years, the present Prime Minister of Israel, his name is Benjamin Netanyahu. He is in the news a lot these days because of the Hamas-Israel war, and we're going to talk about that as well in just a few moments in connection with another legal proceeding overseas. Benjamin Netanyahu, a lot of focus on him in recent times because of the war and the statements that he has made in prosecuting that war, but also much in the attention of national news watchers and all of us because he has been charged inside his own state of Israel, domestically, by the courts, by the prosecutors there, with some allegations of fraud and a misconduct in his office as prime minister. And so it was significant that just this past week, when it came to resolving a major issue having to do with a proposal by Benjamin Netanyahu, the prime minister of Israel, to limit the capacity of courts to do what courts do in Israel and, yes, in every democracy around the planet, the Supreme Court of the State of Israel issued a major decision, a major opinion that's going to affect the balance of power in Israel, that comments upon this relationship between the executive branch and the courts. When we come back after this, our first break, we're going to tell you more about that major decision, that rule of law decision coming out of the Supreme Court of the State of Israel. Stay with me for that all-important discussion. We are back here in our Saturday morning broadcast talking initially about this major case involving the rule of law in Israel that has implications for us right here in our own nation and our own state. This was the first rule of law news event of the new year, January 1 of this year, a major decision coming out of the Israeli Supreme Court. And that case, a momentous ruling that could in fact ignite something of a constitutional crisis in the country of Israel, because on Monday, January 1 this year, the Supreme Court in Israel struck down a law that was passed by Prime Minister Benjamin Netanyahu's government, including, of course, the parliament there, that was meant, in effect, to limit the court's own powers. And that was done by a majority of 8 judges to 7. It was a divided court, much as we have seen here in our own United States Supreme Court. Now, the decision is likely to rekindle a grave domestic situation that we reported on here in our Saturday morning broadcasts and in others of Civic Media that sparked nationwide protests when proposals by the Netanyahu government to limit the role, limit the discretion, limit the power of the judiciary in Israel were met by protests and by objection, strong objection. People in Israel took to the streets, professionals of all kinds and people of all kinds, of ages, races, a national origin, all kinds of people took to the streets in Israel, and they protested this movement by the Netanyahu government to try to limit the capacity of the Supreme Court and other courts there in Israel to do the job in the way it was supposed to do. The court, again, on January 1, a couple of weeks ago, sitting with a full panel of all 15 judges for the first time in its history, the first time in Israeli history, the Supreme Court in that nation, at that time rejected, again, by a split in its membership, rejected this law that was passed by Parliament. And that law was passed back in July of this last year. What did it specifically do? It barred judges across the board in all judicial positions from using a particular legal standard called reasonableness to overrule decisions made by government ministers. And you can see why it is that maybe the executive branch would be concerned about this issue. If indeed there is a change in the standard that gives the executive branch more discretion to do whatever it wants to do, that can not only limit the judiciary's role, but also increase the executive role when it comes to the administration of justice. So what do we need to know about what happened on January 1 and why this is so important in terms of the rule of law and the balance of power between the executive branch and the legislative branch and also the executive branch? The governing coalition, Benjamin Netanyahu's governing coalition, at the time was exercising its authority, trying to establish once again some level of supremacy over the decisions of the judiciary. They argued, as I said, that this legal concept, this principle of reasonableness, which the court used about a year or so ago to strike down some of Netanyahu's appointments. In particular, there was a finance minister who was a political ally of his. They struck that appointment down because on the basis of reviewing that process and the substance of that appointment, determined that it was not a reasonable thing for the executive branch to do. And that particular person had been convicted of tax fraud. The concern, of course, was that this was an unbridled, inappropriate excursion by the judiciary into the executive branch. That was the allegation made by Netanyahu and his government. The Likud party, which is the party advanced and which is led by Netanyahu, called the Supreme Court decision basically pushing back on and limiting this attempt to limit its own authority. They called that decision on January 1 in opposition to the nation's desire for unity, especially in a time of war. The Likud party, including Mr. Netanyahu, slammed the court for ruling on the issue when Israeli soldiers are fighting and endangering themselves in battle, which is what he said. There are others, of course, on the opposite side that heralded this decision, that struck down this law that would have limited the Supreme Court's discretion, its ability to review actions of the executive branch. The Kaplan Force, which is one of the activist groups in Israel that had organized these major protests of this past year against this kind of judicial reform, praised the Supreme Court's decision at the time and called on all parties, everyone in the state of Israel, saying, today one chapter ended in the battle to protect democracy and a victory for the citizens of Israel. So again, strong disagreement about what the Supreme Court has done. For months, as I said, the opponents of Israel's judicial overhaul had crowded the streets of cities like Tel Aviv and Jerusalem to protest the Supreme Court overhaul, which aimed to lessen the court's powers. The protesters said those measures would leave the court unable to prevent government overreach, and many feared that the Netanyahu government in particular, which would be unbounded then by independent courts, would find it easier to limit the prosecution of Benjamin Netanyahu, which is how we began this reporting. Why is all of this important? Why is it significant for America? Well, plainly Israel, one of our major allies in this nation, but also a signal about how judicial matters should work in any democracy. That is, proposals here by the parliament, by the executive branch, reviewed by the judicial branch. In the end, the justices there determining that the legislative decision was an overreach and that, in fact, the executive branch, the prime minister, and the parliament that had passed this law was not doing that consistent with the laws, the understandings of how government is to work. That's how that checks and balance process should indeed work. One can disagree with the result by the Supreme Court, which is also the glory and the joy of republics, to be able to articulate your disagreement with a Supreme Court, to find that indeed the opposition party is the one that has the greater sway when it comes to arguments. All of that is a part of a free and open democracy. We will see where this goes in Israel, but significant that that happened after months and years of protest over the proposal itself. It may not be the last word, as it often is not in democracies, as we have seen here in the United States of America. Just because the Supreme Court articulates in our nation what it is that they feel is the law does not mean that others have that same view. When we come back, we'll talk more about another story having to do with Chile. Stay with us for that discussion. Spoken in our first segments about this significant decision coming out of the State of Israel, including the Supreme Court decision to reject this proposal by the Netanyahu government to limit the authority of judges and justices in Israel. Let's move to another story, also in the rule of law, also overseas. It has to do with Chile and its constitution. Significant issues here, which we've also talked about in the distant past here on our Saturday morning broadcast. Chileans recently rejected a new constitution, looking at a new constitution that would, from all perspectives, have pulled the country probably to the right, likely ending now a very turbulent, about a 4-year process to replace their national charter with little to show for it, and basically going back to the constitution that was in place before this entire process worked. Recently, nearly 56% of voters in Chile rejected the proposal for a new constitution, and that amount based upon the most recent counts coming out of that nation. What is this story all about? The second time in 16 months that Chile, this South American nation of 19 million people, has rebuffed a proposed constitution. The other constitution was written by people on the left side of the political calculus. And all of this shows, again, in lessons for us here back in America, how deeply that nation, like ours is, remains over the set of rules and regulations by which it is to be governed after about 4 years of debate. That debate began in 2019, way back in 2019, after there were enormous protests. They were prompted by a national referendum back in 2019. In that referendum, as a result of it, about 4 out of 5 Chileans voted to scrap their then existing constitution, and a heavily amended version of the 1980 text adopted under the bloody military dictatorship of General Augusto Pinochet. Many of you remember him well from history, a major figure, a dark figure in Chilean history. A decision, again, beginning back in 2019, now having failed to agree on a new text, the nation will muddle through with the Constitution that so many had voted to replace. That Constitution of Augusto Pinochet remains in place. In the wake of this back and forth by Chilean voters in recent years, the present president in Chile said this. His name is Gabriel Boric. He said, "I want to be clear, during my term, the constitutional process, that is the people of Chile deciding on which constitution they will embrace, if either one of them is now closed," he said. He said the country became polarized and divided, and despite this conclusive result, the constitutional process by which the people identify which constitution they will embrace, which constitution they will adopt, failed to channel the hopes of achieving a new constitution written by all. Those are the comments, those are the words of President Boric in Chile in the wake of this vote of recent times coming out of the Chilean population. The process here is significant because, once again, it shows not only the divisions inside the Chilean population, but this attempt to identify a new constitution that would have replaced the one that was put in place by Pinochet many years ago. Chileans twice elected, mostly political outsiders, some doctors, some engineers, some lawyers, farmers, some social workers, other people, to constitutional assemblies to draft some new proposed charters. They sent basically to their seat of government a representative group among them to put together a new constitution. But those bodies that they sent, we would call it a constitutional convention here in our nation, they ended up with creating a long and very complicated series of constitutions that were each in their own ways partisan reflections of their own political views and political inclinations. And as a result of that, the Chilean population in these two series of elections of recent times rejected the one on the left and then rejected the one on the right. The left-leaning assembly last year offered a constitution that would have expanded abortion rights in the Constitution, given some indigenous groups there in Chile more sovereignty, and enshrined a number of civil rights in the Constitution, including a right to housing, to internet access, to clean air, and to care, as the Constitution text said, from birth to death. That was one of the constitutions that was proposed, ultimately rejected by Chileans as being too liberal, as some of them said, too much to the left. After 60% of the ballots rejected that particular text, the voters elected conservatives to put together and control a new constitutional assembly, and that group is the one that came up with the latest constitution. That proposal would have given the private sector a prominent role in things like health and education and social security, social welfare generally. And that proposal also generated this fierce opposition. Voters were overwhelmed, if you will, by the complexity of that second attempt to put together a new constitution, some contradictory information in the public domain about what the two constitutions would or would not have done, misinformation flying from both sides as a result of this process, again, shades of what we have experienced here in the United States of America. What is the result of this? And again, why is it important to understand what happened there in Chile? People went to the polls to try to adopt a new constitution. They have a divided population there, not right down the middle, but fairly close, as we do perhaps in our nation as well. And in the end, as the president recently declared, the process, while it's difficult to say that it did not work, certainly did not result in the adoption of a constitution that everyone felt had to replace the one that Pinochet had put together many years ago. And so for now, at least, the people of Chile will not have a new constitution, but will continue, as many folks have said there, to muddle through with a constitution that is old and does not properly reflect probably the views of the left, the right, even those majority who may be in the middle. And so we'll continue to watch that story as well about the capacity of a people to define what their constitution, what their government is all about. In the case of Chile, at least for now, in 2023 and 2024, unable to come to a decision and therefore keeping their present constitution in place. Lessons for America, perhaps, in both directions about the future of our nation, just as it is about that nation in South America. And then we go, a third case, a third matter, also involving the rule of law, also involving a significant major nation in the South American continent. And this case, again, comes out of Suriname. Former Suriname president, his name is Desi Bouterse. His conviction for involvement in the killing of 15 people more than 4 decades ago was upheld by the judicial and other governmental authorities back in December. And now, as a result of a decision made by the public prosecutor just this past week, the former president, again Desi Bouterse, must report to prison. this coming week in the wake of his conviction for the killing of 15 people 40 years ago. A 3-judge panel there, again, the judiciary involved in making this decision to implement the rule of law there in Suriname, affirmed the convictions of Bouterse and 4 others in the execution of government critics, lawyers, journalists, union leaders and soldiers, and also university professors in December of 1982. He undertook this, according to the findings of the court, as a part of his actual oversight and administration of government. Bouterse, 78, had dominated politics in this former Dutch colony there in South America for decades. He left office in 2020. He, of course, denied the charge, but was sentenced to 20 years in prison. The former president and his army leader have until Monday to request a pardon. They have not done that as of the time that we are talking about this right now. And again, according to the judicial authorities now, Bouterse and the others are required to show up and appear at the Suriname jail along with the 4 co-defendants to begin service of their term. The current president, his name is Jean Santelle, investigated these so-called December murders when he was a police commissioner, and later as a justice minister pushed the case to move forward. The court ruled, again as a predicate to what was just announced recently, way back in 2019, that Bouterse had overseen an operation in which soldiers abducted 16 leading government critics, as I identified them just a moment or so ago, murdering 15 of them at a colonial fortress in the capital of that nation. The former president, again, Desi Bouterse, said in the past that the murdered men were connected to an invasion plot. That's how he explained what had happened to these people in Suriname. He said they were involved in an invasion plot involving the Netherlands and, yes, indeed, the United States of America. That was, of course, rejected as a defense in that case. And as a result of all of this, the former leader of their nation in Suriname is now required to show up to begin serving his 20-year term of imprisonment coming this week. What is the significance of that for our nation? We are not used to this notion where a former president is prosecuted. We do not know what will happen plainly with Donald Trump in 2024 and beyond. But the reality is that in other nations around the face of the planet, there are situations, there are circumstances where the judiciary, prosecutors, the rule of law is invoked to ensure that no one is above the law. In this particular case, the ex-Suriname president convicted of killings, these ordered killings by him and others, convicted of that and now facing the sentence imposed upon him as a part of the administration of justice, the search for the rule of law. And I would offer, based upon the results of this process, taking 20 years to finally adjudicate, finally coming to a place where the person responsible for them, according to the prosecutors, according to the courts in Suriname, now going to prison for that misconduct involving killings of people who were plainly his political adversaries and others while he was in office. Significant as we understand what may or may not happen in the United States in the years to come. And finally, we have beginning just this past week, a major piece of litigation. It is in the international court involving South Africa and Israel. This involves The Hague, in particular, an allegation brought by South Africa against Israel. South Africa, representatives of that nation, and Israel exchanged some allegations and, in fact, argued before The Hague, which is the top UN court, about what is going on right now in Israel and Hamas. And in particular, the International Court of Justice, the ICJ at The Hague, which is also known as the World Court, held sessions on Thursday and Friday of this past week. And a case was initiated by South Africa in late December. And in that case, brought by South Africa in this international court against the state of Israel, claiming that Israel had failed to uphold its obligations under the 1948 Genocide Convention. We do not know what will happen as a result of the arguments, presentations made in front of The Hague just in the past couple of days, but we do know about how this came about and what the positions of the parties have been as articulated in just the past couple of days. Both parties, both Israel and the state of South Africa, are right now parties to this convention, which obliges them to not commit genocide and also to prevent and punishment. When we come back after this break, I'm going to tell you more about the opposing positions articulated in The Hague just in the past couple of days, and what the court there, the timing of the court's decision, which will probably be years in the making. Stay with us for that discussion about the fourth of these international cases involving the rule of law. We are back for this, our final segment of this, our first hour in our Saturday morning broadcast, talking about international matters that focus upon the rule of law and that also give us some instruction, some guidance about how we are to administer the rule of law here in the United States of America as well. Important to understand that we are a part of an international community, and as a part of our discussion this morning, now looking to The Hague in the Netherlands for this dispute between South Africa and Israel. And right before the break, I explained the jurisdictional basis of this court. Both countries having signed on to an agreement that obliges them not to commit genocide and also to prevent and to punishment. The treaty defines genocide as acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group. The undeniably politically charged hearings that took place at The Hague just in the past couple of days will deal in the future, as the court wrestles with the resolution of that. They certainly focused on it in the past couple of days with South Africa's request for emergency measures that would order Israel to suspend its military actions in Gaza while the courts hear the merits of the case. So a focus on an injunctive attempt to stop Israel from doing what it's doing, a process, again, that could take years. And again, let's talk about what the opposing parties are saying about this. The South African president had said before the proceedings were initiated, he said this: "Our opposition to the ongoing slaughter of the people of Gaza has driven us as a country to approach the ICJ," again, that's the International Court. "As a people who once tasted the bitter fruits of dispossession, discrimination, racism, and state-sponsored violence, we are clear that we will stand on the rights of history," and indeed that's what South Africa argued during the course of the past couple of days. Now, on the opposite side, again, this is how the rule of law works, right? This is how justice is administered in an international community as it is in a national community. Israeli government, the spokesperson there, and the advocates there said the state of Israel will appear before and has appeared before the International Court of Justice to dispel what they called South Africa's absurd blood libel, as Pretoria gives political and legal cover to the Hamas rapist regime. That's what the Israeli defenders of this have said, and went on to say this: on October 7th, Hamas committed an act of genocide when it sent death squads to invade Israel with the mission of burning, beheading, torturing, mutilating, abducting, and raping as many Israelis as they could, as brutally as they could. It was a campaign, the Israeli lawyers and presenters said. It was a campaign of systemic extermination that they have vowed to continue until our country, Israel, is destroyed. We are fighting to bring the October 7th monsters to justice because never again is now. And so, as you know, plainly in the wake of those descriptions of both sides of this presentation to The Hague this past week, very, very hotly contested, underscoring once again not only the nature of those differing views, but about the importance of the rule of law even inside The Hague, once again underscoring the notion that it is through this process of presenting evidence, making arguments, that resolutions, certainly imperfect, certainly not in the agreement of everyone who comes out of them, are ultimately rendered. We will see what the International Court does as a practical matter in this particular case, not only because of the focus, the extensive focus of the allegations and the equally extensive nature of the defense in this case. It is predicted that the International Court of Justice there, The Hague, will take years to determine exactly what will happen here. We certainly all hope that the war in the Middle East involving Hamas and Israel will be long over by the time they were to render any decision here in The Hague, in the Netherlands, in the wake of this case. But it is significant as well, as I indicated, that South Africa is also seeking some injunctive relief from the court, asking that Hamas and the Israelis involved with them in this war also be subject to more immediate judgment. And the judgment that South Africa is looking for is a directive that Israel stop some version of the war that it is now undertaking. A basis for many people, obviously reasonable people, can in fact make arguments on both sides of this. The notion and the reason why this is important to understand what's going on in our national arena, on our national and international scale, is that this is how legitimate judicial bodies should in fact undertake to hear evidence and to resolve cases ultimately, again, as I said before, not to the resolution, the complete satisfaction of everyone, but based upon a system of laws and justice to which we have all agreed. We will continue to monitor that case as well going forward in The Hague. All of those rule of law cases, again, involving Israel, involving Suriname, involving Chile, and involving South Africa and the Middle East and Hamas and Israel, all of them speaking to us here in America as well, and giving us some instruction about the rule of law, about the delivery of justice in the international forum, from which we may or may not take perfect lessons, but nonetheless understand the importance of the trifurcation of government, that is an executive branch, a judicial branch, and plainly a legislative branch as well. When we come back, we're going to come back to the United States of America and talk about matters and cases pending in our own courts. Stay with us for the next hour here on our Saturday morning broadcast.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle. Sampling the news desserts of the week, here is your host, Jim Santelle.
And we are back on this, our 80th broadcast here on the broadcast stations of Civic Media, our Saturday morning show focusing on significant events, circumstances, developments in the areas of law and government and the aspiration for justice in America. This is our 80th broadcast, and I thank you, as always, for listening in every Saturday morning, or every Saturday morning that you are able to listen in on. Every Saturday morning, if possible, when we talk about these important issues for our world, for our nation, and our state as well. As always, supported in my studio here in Waukesha by my wonderful producer, Anya, who together with me is presenting our program this morning and every Saturday morning. In our first hour this morning, spent a lot of time talking about international rule of law matters, some undiscovered justice out there, not because it's completely undiscovered, but because it has not been the focus of a lot of our national media. Things coming out of Israel and Chile and Suriname and The Hague, all of them underscoring the importance of things like a judiciary that is responsible for providing a check and a balance to the executive branch and the parliament. The importance of a constitution, that is, a constitution that's embraced by the people of a nation, or in the case of Chile, rejected a couple of times in the population's attempt to identify a new governing document for its nation. In Suriname, the notion that even the most highly placed individuals, people in the executive branch, the president there, are not above the law and are responsible for the things that they do in office. The president, the former president there, reporting to prison in Suriname this coming week, having been previously convicted, his appeals having been basically rejected there in that nation, now responsible for showing up in prison and serving his prison time for the things that he did while he was in the position of president, the chief executive of that nation. And at The Hague, the importance of the rule of law in a courtroom, this time brought by two nations, South Africa and defended by Israel, having to do with the Hamas-Israel war right now going on. All of that underscoring for us the importance of the mechanisms by which we establish basic standards and processes for government in republics where the people are the ones served by government, and the people have a right to expect not only balances of power, checks and balances, but also the supremacy of the rule of law over and above any single individual, over and above any single institution, all of that in service to the people who ultimately give power and force to the government itself. From Israel, from Chile, from Suriname, and yes, from The Hague in the Netherlands, lots of things from the past several weeks to take notice of as we move back now to our own nation, the United States of America, and take some inventory of some of the cases going on in the courtrooms of our own nation. Let's begin. Let's begin in New York, as we often have. This past week, Judge Arthur Engoron, who is the state court judge, actually called justices there in the state of New York, presiding over the trial. You may recall well, this is the civil trial. It's not a criminal trial. A civil trial, a civil complaint brought by the Attorney General of the state of New York, her name is Letitia James, seeking now $370 million against the Trump organization, and also, perhaps even more significantly, seeking to stop the Trump organization from being effectively incorporated in New York, being able to operate not only real estate, but also other things, the other trappings of the Trump organization for years and years and years, basically barring him and the company from serving in an official capacity under the rules and regulations of the state of New York. The basis for that lawsuit, which again has now concluded in the wake of oral arguments of the past couple of days, now before the judge, determining what kinds of remedies will be imposed by the court upon Donald Trump, his sons, and the corporation. You may recall well that Justice Judge Engoron previously, even before the evidentiary portion of the trial began, he had determined on what's called a motion for a summary judgment
judgment, had entered an order finding that fraud had existed. And the trial that was conducted in the wake of that pretrial determination was basically to flesh out some additional counts in the civil complaint brought by the Attorney General, but again, mostly to determine what, if anything, should happen in the wake of that finding of fraud inside the Trump organization. And so, this past week, specifically Thursday and Friday, the defense, on behalf of the former president, had an opportunity to present its case, to argue as the defense did, that the prosecution, the state, had not met its burden. And interestingly, along the way, a significant procedural matter happened. There was a proposal by the defense right before the oral arguments began for Donald Trump himself to deliver the closing argument on his own behalf. Now, in normal circumstances, in a civil case, certainly in a criminal case, it goes one way or the other. If you are represented in court, you speak through your attorney. If you are not represented and you're representing yourself, then you speak on your own behalf. In this case, the judge, again giving Donald Trump an awful lot of latitude, as he has during the course of this trial, said that I will permit Donald Trump to speak in court as long as what he says is not testimony, as long as this is not a campaign speech, as long as he does not attack, as he has publicly, the judicial officers, the law clerks, the attorneys general, the other people involved in the prosecution of this case, as long as he does not turn this into anything other than a summary of his perspective on what the trial showed. And in the end, the defense, the Donald Trump team, rejected that because, according to their own statements, they could not abide by those very legitimate impositions, those restrictions, if you will, imposed legitimately by the judge with respect to anything that Donald Trump may say. Now, what happened in the end was, even as counsel for Donald Trump was making the case that the case should be dismissed, the government had failed to meet its burden of showing the extent of the $370 million fraud, showing the entitlement to stop the Trump organization from going ahead. During the course of that, counsel once again asked Judge Engoron if their client could speak. And Judge Engoron basically reversed himself and said, well, all right, I will permit Donald Trump to speak briefly. He said, I'll give you 5 minutes. And sure enough, during the course of that presentation, as Judge or Justice Engoron predicted, Donald Trump, while refuting some of the basic core allegations, some of the portions of what he said may have arguably been in the category of a legitimate closing argument. Most of it was an attack upon the legitimacy of the process, arguing this was political in nature, the kinds of things that he has said in the public domain, which he said, frankly, right before and right after the oral arguments themselves, attacked the court itself that's going to be deciding on the very merits of the case that it presently has before it. It was precisely what Judge Engoron had predicted. The case came to an end based upon that defense presentation. Donald Trump quite literally given his day in court in a way that no other civil or criminal defendant would be afforded in the courts of America, given this special opportunity. And Friday, of course, the prosecution, the state of New York, once again summarizing all of the evidence. You may recall that in the initial complaint, Letitia James was seeking $250 million. She sought $370 million in the end. Why? Because based upon the evidence was discussed by the prosecution just yesterday, the evidence premised upon the documents, the testimony of people inside the corporation, and very, very specifically, testimony by people who have looked at the documents, financial experts examining all of this, talking about the transactions, talking about the core valuations that were at the center of this complaint, all of that mathematically coming up to $370 million in fraud that, again, the judge had previously found. And then also arguing yesterday that the judge not only impose that kind of financial assessment, but also that Donald Trump and his corporation be barred from future corporate activities there in the state of New York, Why? Because if the court finds, as it has, that fraud has existed, and indeed that there should be remedies for that, one of those, this is what the government argued, one of those should be basically disbarment, from being kicked out, if you will, of the legitimate area of corporate entities in New York and being prohibited from the future involving real estate transactions and other things that the corporation itself does. That arguably, if Judge Engoron grants that portion of the request for some remedial response to all of this, if the judge grants that, that may in fact be a larger penalty than even the monetary amount itself is, because it would stop the Trump corporation and Donald Trump from doing what it has done for most of our natural lives, at least since Donald Trump and the corporation have been around in New York and in other places. Now, in the wake of whatever Judge Engoron does, and by the way, he has promised a decision by the end of this month, coming up quite soon. He probably has already begun to put together the outlines of his decision, but he will plainly codify, if you will, his findings in a written decision that will be issued. We will talk about it certainly on this Saturday morning broadcast, as will other broadcasts of Civic Media. The judge will issue a written opinion. And in the wake of that, two things will probably happen. One is that Donald Trump will appeal that to the appeals court, which is his right. And second, there will also be a request that that decision, whatever it is by Judge Engoron, be stayed, that it be limited while that appeal is going ahead. When we come back, I'll tell you a little bit more about the prospects for those things happening, and then move on to another civil case pending in New York, and some other criminal cases also pending in the courts of our nation. Stay with us for that important discussion. And we are back. We are talking now in this second segment of our second hour on our Saturday morning broadcast about cases pending in the United States of America, all of them, once again, in pursuit of the rule of law, justice, and also the effect of government prosecutions, civil and criminal, talking in particular about this major civil fraud case now coming to a conclusion in New York just in the past couple of days, with closing arguments having been presented by the prosecution, the state of New York, and also by the defense. The defense obviously arguing that the case should be dismissed, the prosecution maintaining before Judge Engoron that a judgment in the state's favor should be entered by him in this written order that he is going to be issuing, he has said, before the end of this month. And again, that order going to be a conclusion to the trial court proceedings. What happens in the wake of his issuing that decision? Well, almost certainly Donald Trump, assuming that Judge Engoron imposes some significant penalty, and may also impose the penalty of basically bringing the Trump Corporation to an end. If that happens, or even if something short of that happens, Donald Trump and his attorneys will appeal. There's an appeals court plainly in the state of New York. And that process, quite literally, through the appeals court, perhaps even to the highest court in the state of New York, will predictably take at least months, if not years, before this is ultimately all resolved. Now, along the way, Judge Engoron has another decision to make, and that is whether or not to stay, basically to take his opinion and not put it into effect while those appeals, while the challenges to his order are pending. And that's a decision that he is going to make based upon his view about the extent to which an appeal will be successful. Probably, predictably, this particular trial judge, who has been quite clear in his finding about fraud, and quite clear that with respect to this particular defendant, many of the things that he has done in his official capacity in charge of the Trump Corporation are things that run afoul of the New York laws. While he has said all of that, he has also, as I've indicated in the previous segment, given Donald Trump an awful lot of leeway when it comes to substance and even process in this trial. It is likely, if not completely predictable, that Judge Engoron may stay his decision, may say, you know what, you can go to the appeals court, have the appeals court review this very large omnibus decision that I am now rendering, and then, and only when, the entire appellate process is completed, will it go into effect. Likely he will do that, but doesn't have to do that. If he decides that his opinion, his judgment, his decision will not be stayed, Donald Trump could also procedurally go to the appeals court and ask the appeals court to stay the lower court decision. A lot of process there, a lot of civics there, a lot of law school there, but all of that coming up in the wake of what is now approaching the conclusion of that major fraud trial that we've been talking about on this broadcast for quite literally the entire time that we have been on the air. The appeals will follow with certainty. Another civil matter also going on in the state of New York coming up this coming week. This is in federal court, and we have heard about the plaintiff in this case, in this private, non-government case, civil case before. In addition to the 4 criminal indictments that we know about, Donald Trump is also facing, as I just indicated, this civil lawsuit, the civil fraud trial, and another civil case, among many others, candidly. This one is one in which writer E Jean Carroll's second defamation case against the former president is proceeding apace. The district court judge, the federal district court judge, his name is Lewis Kaplan, is overseeing the case. You may recall that way back in October, we talked about a major decision that he rendered, about a 27-page decision, a pretrial order in this particular portion of what basically is a 2-part defamation piece of litigation that E Jean Carroll has pursued. All of this ultimately going back to her allegation, now proven in the first case, that during the course of an encounter with Donald Trump in a dressing room at a department store in the mid-1990s, he sexually assaulted her. Her allegations were both that happened, and also that he subsequently defamed her in connection with denying that happened and making some other scurrilous comments about her. Judge Kaplan's order in the fall of the previous year made it abundantly clear that the case that's now going to go ahead this coming week, the second portion of this, if you will, is only going to get worse for Donald Trump in terms of the presentation. Now, why do I say that? Well, until recently, the former president's lawyers have been preparing plainly for this upcoming defamation trial, again, in the federal court, almost as if the first one, again, finding that defamation happened. You may recall that was also the case in which about a $5 million judgment was entered, almost as if that had never happened. And this is being seen, or was being seen, by the trial lawyers at the time as a second chance to sort of rewrite history in this particular matter and try once again to clear Donald Trump's name after a jury last year again concluded just the opposite, that he had in fact sexually assaulted E Jean Carroll and that damages should follow. In the order, in the district court judge's order, Judge Kaplan wrote, "The material facts concerning the alleged sexual assault against Carroll have already been determined." That's what the trial judge wrote. And this trial, the one coming up this coming week, he said, will not be a do-over, those are his words, not mine, will not be a do-over of the previous trial. This new jury, he said, will probably see some of the same evidence of misogyny from the Access Hollywood tape, in which Donald Trump, as you all may regrettably recall, talked about grabbing people. The videotape deposition, in which he remarks that stars get away with sexual assault, unfortunately or fortunately, all those kinds of things that Donald Trump said that were part of the initial trial also being presented here. The previous iteration of this case, along with those previous defamation denials by Donald Trump, also a part of the forthcoming trial this coming week. When we come back after this break, I'm going to tell you more about what we can anticipate in this second trial, and then talk about other trials going ahead in the weeks and months ahead. Stay with us as we continue our discussion here on our Saturday morning broadcast. Talking now about another civil trial going ahead next week in a federal district court in New York. This one being brought by E Jean Carroll, once again alleging defamation by the former president. How does this one play out? It begins again next week. It deals with the denials Trump made as a United States president, with all the additional attention and gravitas that his former position of power bestowed upon him at the time that he made these comments. And in particular, this is the trial that is premised upon the claims that he made while he was the president of the United States of America, that the things that E Jean Carroll had said about this sexual assault that happened in the Manhattan store back in the mid-1990s, that they were not true, that he never met this woman, as he said, and that denying that she had engaged with him at all, that he had engaged her at all, that any of this ever had happened. And so this time in this second trial, again beginning next week, much of the same information and evidence being presented, but once again focusing upon statements Donald Trump made while he was the president of the United States of America. And you may think, why is this now first coming forward? You may recall as well that there was a lot of litigation about whether or not Donald Trump's statements at the time that he was president, these allegedly defamatory statements against E Jean Carroll, whether those things were again protected by his position as president. The Department of Justice, incredibly, for a long time had taken the position that indeed those things were things he said in the course and duties of his responsibilities, a position that I found ridiculous. The Department of Justice ultimately reversing its position and saying, no, indeed, those things that President says that are defamatory in connection with a private matter, plainly involving sexual assault in his past, those things are not a part of the duties and responsibilities of a president. Ultimately, the Department of Justice coming around, reversing its position, and effectively permitting this case to go forward, even though it is the second matter that parallels in many ways the previous case involving defamatory statements made by the president after he was in the Oval Office. A lot there to digest. The upshot of all this is that another trial underway, but the judge, while indicating that much of the evidence will be the same, this is not a do-over, as he indicated. Judge Kaplan plainly finding that the results of the previous trial, in which the findings about sexual assault and defamation already were found by a jury, will loom large in this trial as well. And again, why are we talking about that this morning? It focuses not only upon the process, by which our federal and, yes, indeed, our state trial courts administer justice, the notion of filing a complaint, doing discovery, much of which, again, will be presented in the course of this trial, and ultimately having a day in court to present that evidence and having a trier of fact make determinations about what happened, in this case, sexual assault, and most specifically, focusing on defamation, a second trial based upon things that Donald Trump said during his presidency. Shades of that also having to do with this larger issue of immunity. As I said just a moment or so ago, the Department of Justice finding that the things that a president says that are not within the duties and scope of his responsibilities while being president are in fact subject to prosecution civilly. That's basically the finding in the E Jean Carroll and other matters. Also the subject, as you well know, of the third case we're going to be talking about this morning, and that has to do with this major matter, focusing upon whether a chief executive has immunity when it comes to the things that he, perhaps one day she does, while in the office of the presidency. Not exactly the same positions, not exactly the same theories as being presented, but very close in terms of the protections being granted or not being granted to a present or former president. I have spoken before at great length, and I'd like to think clearly about the notion that this argument that a chief executive, a president of the United States of America, is completely immune from civil, and in this case now, criminal prosecution is absurd. I've used the word ridiculous. I've used the word completely frivolous, and indeed it is. It is concerning to me and concerning to many other people that we are spending, candidly, so much time diverting the movement forward of the criminal case, the January 6th case being prosecuted by Jack Smith in the federal district court in front of Judge Tanya Chutkan. That case right now alleging in 4 counts against Donald Trump his involvement in the attempt to interfere with the 2020 election results. That case now being effectively suspended in terms of the trial date, in terms of other things going on, being suspended by virtue of wrestling with this immunity issue, which should not be difficult for any judge, a trial judge, an appellate court judge, a Supreme Court justice to wrestle with. The upshot is that a president, as Judge Chutkan wrote, is not a king. And if indeed any set of judges, the appeals court before whom this matter is now pending, the Supreme Court before whom it could pend in the future, if any set of justices finds that indeed a president is immune, in this case from criminal prosecution for the crimes that he or she one day has committed during the course of his presidency or her presidency, if a court should find that, our republic comes closer to the end. Then we do return to a time of kings and the supremacy of kings that we have discarded 240 years ago in this country. So what happened? What happened just this past week? Again, in a case in which Donald Trump actually appeared in court. We talked before about the fact that he appeared and actually spoke during the course of the oral arguments, the final arguments in the civil trial case in front of Judge Engoron, the fraud trial in the Manhattan State Court. He also appeared in the appeals court in the District of Columbia, also just this past week. Now, in this particular case, he did not speak. And that's, again, the appropriate way for this to happen. On appeal, when you take up a decision made by a lower court judge, it is not a retrial. You don't have a chance to provide oral testimony. This is not a time for reintroduction of documents or the presentation of more oral words, commentary by witnesses. This is a time for truly argument by the judges, by the lawyers themselves, in front of the judges who question the lawyers about what happened at the lower court. Indeed, that's what happened just this past week. And so, a 3-judge panel from the Federal Appeals Court in Washington, D.C., heard oral arguments just this past Tuesday on this issue of whether or not a president is immune from prosecution for the things that he does while in the presidency. It's a very significant case in the completely outrageous and remote chance that the appeals court, or ultimately the Supreme Court, says that yes, indeed, this immunity notion does have some legs. If that would happen, plainly, it would prevent the prosecution not only of the pending case involving the insurrection, the interference case being prosecuted in front of Judge Chutkan, but arguably also at least a portion of the case being presented in front of Judge Eileen Cannon in Florida as well. That's the documents case, the Mar-a-Lago documents case. So it has a huge impact not only upon the prosecutions going forward, but I would argue more importantly upon the future of our nation. Again, frustrated only because this very simple issue, which should not be taking the time of our appellate court judges, is in fact not only doing just that, but also arguably postponing the ultimate trial of Donald Trump on this singularly most important case of the 4 criminal cases that are pending against him. So let's talk about what happened in front of the appeals judges just this past week. Again, they are the District of Columbia Circuit Court, 3-judge panel. 2 of them, the judges' names are J. Michelle Childs and Judge Florence Y. Pan. 2 of them very articulate in terms of doubting seriously the position being advanced by the defense and on behalf of Donald Trump. And the 3rd judge, also Karen Henderson, likewise suggesting that she is not going to be buying into this notion generally, but for slightly different reasons. So let's kind of pull that apart. Let's begin with Karen Henderson in particular. What did she say during the course of the exchange, the oral argument that happened just this past Tuesday? Donald Trump present for it, but not speaking. His attorneys engaging in colloquy and conversation and disagreement, if you will, with the 3 judges, Childs and Pan and Henderson. Judge Henderson rejected this central portion of the Trump argument. What was that? That his efforts to overturn his loss to President Biden cannot be subject to prosecution because presidents, according to Donald Trump, have a constitutional duty to ensure that election laws are upheld. Now, the last portion of that, plainly, we could all agree with, but Judge Henderson was objecting to the first portion of that in the manner by which he was arguably ensuring that the election laws are advanced and enforced, he was engaging crimes. She said this in particular from the bench on Tuesday this week. She said, "I think it's paradoxical to say that his constitutional duty to take care that the laws be faithfully executed allows him to violate the criminal law." That was Judge Henderson speaking to Donald Trump's lawyers just this past week. She's still at the same time expressed some worry around the edges that allowing the case to proceed, she said, could open the floodgates of prosecutions of former presidents. She raised the possibility of sending the case back to the federal district court, that again is Judge Tanya Chutkan, for some greater scrutiny, some greater review of all this to consider the specifics of Donald Trump's actions. Now, highly likely, once again, that she is not buying into this notion of complete presidential immunity. Significantly, that when it comes to the deciding factor, we heard from 2 other judges, and again, they are Judges Childs and Judge Pan, both of them rejecting virtually outright the core of the position being articulated by Donald Trump and his attorney. Judge Pan, in particular, asked the attorney for Donald Trump to address a series of very interesting hypotheticals, and they were plainly intended to test the limits of this position that presidents have absolute immunity from criminal prosecution when they engage in official acts. And in particular, the position was by the defense that before the government can charge a former president, with criminal prosecution, that president must first have been impeached and convicted by the Senate for the same basic facts, the same matter. Again, none of that in the Constitution, a brand new concept articulated by the defense attorneys in recent times, and again on Tuesday before the judge, Judge Pan and the other 2 judges as well. Among these hypotheticals that Judge Pan asked counsel for Donald Trump, she said this: what if a president ordered SEAL Team 6, again the SEALs, these Navy commando units, she said, what if the president were to order the assassination of the president's political rival? Can he do that? Could she do that and be completely immune from prosecution? And the counsel for Donald Trump responded that such a president would surely be impeached and convicted, but he insisted that courts would not have jurisdiction, would not be able to prosecute over that kind of a murder trial unless that impeachment and that conviction first happened. Again, ridiculous in terms of its presentation in court, even as they're articulated out loud right now on this broadcast. When we come back, I'll tell you more about what happened during the course of this important oral argument before the three-judge panel of the District Court of Columbia and predict with certainty how it is that they're going to resolve this very straightforward issue about whether or not presidents are immune from criminal prosecution for their acts in office. Come back right after this break and hear more about this oral argument. We are back and talking about this all-important oral argument before the United States Court of Appeals for the District of Columbia Circuit happening just this past week. Judge Pan expressing great doubt about this notion that a president has complete immunity for the things that he or she does. The prosecution, of course, also has an opportunity, as they took up during the course of this oral argument this past week, and argued, of course, that the hypothetical president who uses a SEAL team to try to kill a rival and then escapes criminal liability for it would be outrageous. And in particular, suggesting that that's an extraordinarily frightening future. A frightening future is the way that the counsel, again in Jack Smith's office, described the position being articulated by Donald Trump and his attorneys. He also said this. He said, frankly, if these kinds of fact patterns being advanced by the defense, that is on behalf of Donald Trump, arise again, I think it would be awfully scary if there weren't some sort of mechanism by which to reach that criminally. In other words, there can be no basis. There can be no basis for saying that a president is above the law, and for that reason that this immunity doctrine being advanced by Donald Trump and his attorneys have some weight. The judges, again, also indicated that during the course of Donald Trump's second impeachment trial, again making reference to the argument being made by the defense attorneys, during his impeachment trial, his second impeachment trial, his attorneys at that time said that the Senate cannot find him guilty. Why? Because it's only in a criminal prosecution brought by the Department of Justice that a president like Donald Trump could be held responsible for his acts in office. And so basically completely contradicting what the attorneys have said before the Court of Appeals way back when, a long time ago, when the second impeachment proceeding was going forward, the trial before the Senate. His attorneys said just the opposite, that you should not impeach, you cannot find guilty based upon the articles of impeachment because the only remedy that's available is criminal prosecution. Now saying that criminal prosecution is not available because the only remedy, at least the predicate remedy, is impeachment. That also brought out by the two judges, Judge Pan and also Judge Childs, noting the inconsistency in all of that. Now, the judges plainly, I've got before them now, in the wake of that oral argument, a decision to make. Hopeful that they will make that decision a written order forthcoming fairly quickly. It can, from my perspective, be the kind of thing that could be decided in the course of about 2 or 3 sentences, candidly, making reference to the Nixon case, other fundamental principles out there, making reference to what Judge Chutkan has said already, which is presidents are not kings, and the consequences of finding just the opposite catastrophic for our nation. So let's assume rightfully that the Court of Appeals issues this opinion and says that Donald Trump's position is not meritorious, that he is not immune. He will plainly seek review by the United States Supreme Court, and we should hope that the Supreme Court, looking at the frivolity of this argument, would say, you know what, we're not even going to review this. We're not going to grant certiorari as to this, and therefore we're going to deny a further appeal on this. We're going to let the Court of Appeals decision rejecting the presidential immunity concept, we're going to let that stand. And based upon that, then everything goes back to Judge Chutkan, and she can then proceed with her trial, having gone through this diversion, if you will, for a number of weeks, arguably months, while this silly, frivolous immunity position is advanced. The Supreme Court could, in fact, take this case, which would further delay all of this. They could undertake to have briefing done. They could also undertake oral argument down the road. But again, I would offer that this is one of those times when the Supreme Court has got to resolve this in one way or another quickly. The most efficient way of doing that would be to deny even a appeal going forward, which it can do, and bring this back into the realm of the trial court. Let Judge Chutkan go ahead with the trial. Let Jack Smith go ahead with his prosecution as soon as possible on those all-important counts still pending. And that leads me to the final comments of our hour, and that is the Supreme Court. And we've talked before, as we will in the future, about the heavy docket. We know that in just the past week, on Monday, Tuesday, and Wednesday, the court was looking at cases involving everything from immigration cases to no-fly lists to the grants of quarterly fees in Chapter 11 bankruptcy cases. In the coming week, it's got 2 days of oral argument coming up on Tuesday and on Wednesday, having to do with some securities issues, the taking clause of the Fifth Amendment, but most importantly, on the 17th, on Wednesday, this coming week, the court undertaking this major case called Relentless or Raimondo, actually 2 cases, determining whether this thing called Chevron deference will last, whether or not the notion of federal judges deferring to the experts in agencies when the law prescribed by the Congress may be ambiguous or unclear. A major case, again, I would argue, even in the midst of these cases having to do with guns and social media, even the Trump cases, this case called Raimondo or Relentless, I would argue one of the most significant cases for the future of democracy. That's coming up for oral argument this coming Wednesday, the 17th, and having to do with whether or not the Chevron defense, the Chevron deference, the Chevron concept, which has been out there for decades, should in fact be rescinded and turned back in such a way that the federal courts should no longer rely upon the expertise of the people inside our agencies who know what they're doing. We're going to talk more about that oral argument in our next broadcast, and that leads me to invite you to return to us next week, next Saturday morning, for more discussion of the rule of law, the operation of government, and the aspiration for justice in our nation and beyond. I thank you for joining me this morning, and I wish you a good week in support of all the good things that America is about, as together we attempt to pursue justice in every way in our lives and our livelihoods. Have a good week, everybody.